Hello, this is Ken Holland presenting the April 2013 issue of the ConstructionRisk.com report. We'll have 4 articles in this report, and of course you can read them in the newsletter that I have sent to you. You can also read them online at ConstructionRisk.com, or you can watch them here in this short video. The first case deals with a differing site condition. The claim was made by the contractor, but it was deemed by the court to be barred by contract disclaimers. So the contract claimed both a differing site condition clause as well as language in the contract stating that the bidders could not rely on data like soil information that had been provided by the owner with the IFB, but rather the bidder was expected to perform its own site investigation instead. Now, the data that had been provided with the owner's survey really was not accurate. This involved a pipeline that was going to be installed, and the survey showed what they called foreign crossings, and that could be anything from pipelines to utilities, any number of things that would cross over the right-of-way where this new pipeline was going to go in. And the alignment sheets that were included with the bid package showed that there were 280 foreign crossings, when in reality there were about 794 of these foreign crossings, and 200 of those were actually metal pipelines. So you can imagine this would really interfere with the new work being done by this contractor. But the court held that the contract allocated all the risk to the contractor of unknown obstacles discovered during the construction process. Therefore, no recovery. This case was called El Paso Field Services versus Mastech North America, Texas 2012. The next case we're going to talk about is entitled Economic Loss Doctrine Did Not Bar Contractor Claim Against Architect for Defective Specifications. In this case, a structural steel subcontractor filed suit against the owner's architect, alleging that plans and specs were defective and caused delays that economically damaged the contractor. The trial court applied the economic loss rule and dismissed the suit. This was reversed on appeal, with the court holding that the contractor can amend its complaint to include factual allegations addressing 9 factors that are used by the courts to determine whether, in the absence of privity, a defendant owes a plaintiff a duty of care to prevent economic loss. This is a case of Olson and Company versus Nestor and Goffney Architecture. It's a California appellate decision of 2012. After reviewing the allegations that were contained in the complaint, the court concluded that they didn't provide enough information to properly evaluate the 9 factors that were used by the courts to make this determination of whether or not the architect owed a duty of care to a subcontractor. And because there was a chance under California law that, notwithstanding the normal application of the economic loss doctrine, a subcontractor could present sufficient facts to prevail against the architect for breach of duty of care, the court stated the following, quote, "We're reluctant to reach a conclusion based on matters that are not set forth in the pleadings, and we direct the trial court to grant Olson leave to amend to include allegations directed at the 9 factors," close quote. So in this case, the court, rather than dismissing the plaintiff's case, said, no, we're going to let the plaintiff come back in, correct their complaint to see if they can allege enough detail to show that there was a duty owed by the architect. The court said the following, and I'm going to put up a slide with all of this so you can see this. Quote, "The determination whether in a specific case the defendant will be held liable to a third person not in privity is a matter of policy and involves a balancing of various factors, among which are 1. The extent to which the transaction was intended to affect the plaintiff, 2. The foreseeability of harm to him, 3. The degree of certainty that the plaintiff suffered injury, 4. The closeness of the connection between the defendant's conduct and the injury suffered, 5, the moral blame attached to the defendant's conduct. 6, the policy of preventing future harm. 7, the degree to which there might be a potential liability out of proportion to fault. 8, the level of sophistication of the plaintiff in the context of the transaction, including the potential for what the court called private ordering to contractually protect against the risk. And finally, 9, the balance between, on the one hand, efficient loss spreading, and on the other hand, the potential for dislocation of resources. Close quote. Now, just as a comment on this case, this decision and others like it in California, I think, are unfortunate because they really throw the door open very wide to suits against design firms by any project participant at any tier, and they circumvent the normal contractual requirements and expectations that the proper recourse for recovering economic loss is from the party with whom one has a contract. So, for example, a sub, one would think, would recover from its prime. The prime would recover from the project owner. An owner creates an implied warranty of the specifications, such that if a contractor has to do change orders and has to redo work because it could not successfully complete the job with what are seen as defective specs, then the owner owes a change order. The contractor doesn't even have to prove any negligence for that. It's an implied warranty of that spec as between the owner and the subcontractor or the contractor. I apologize, contractor. So again, when we start allowing that to be eroded and allowing a contractor to go and sue a design firm with whom it has no contract, we really start getting out from under the risk allocation that may have been put into the contract. Things such as no damage for delay clauses, or certain limitation of liability clauses, or waiver of consequential damage clauses. So I believe it's very important to try to honor the contract and prevent parties from doing end runs around the contract by going to third-party actions like the one that was in this case. So, my little commentary there. The next case, third case, is entitled Contractor Permitted to Pursue a Tort Claim Against an Engineer for Allegedly Defective Specs and Failure to Approve Payment Requests. This is in Louisiana, and under Louisiana law, a federal district court held that the general contractor on a public contract to build a warehouse could sue the project engineer for negligence based on allegations that the contractor's ability to perform its obligations was delayed and rendered more difficult by the engineer's actions, including the alleged, quote, failure to develop good quality specs, insistence on performance of unnecessary work that delayed the construction project, and failure to approve certain payments by the owner, close quote. The court explained in this case that the gist of the complaint is that the engineer's duties as a construction manager included the obligation to manage the construction project in a way that would allow the contractor to perform its own contractual duties owed to the owner. And the court found that Louisiana recognizes an action for negligent professional undertaking, the essential elements of which are established upon or based upon the facts alleged. So in other words, it would be possible for a contractor in this situation to present enough facts in a complaint to survive a motion, and indeed even to get to a jury to determine whether or not the professional had a professional undertaking and a duty to the contractor. This is the case of Harris Builders versus URS Corporation, 861 F Sup, 746 Eastern District, Louisiana, 2012. The court did a balancing test in reaching its decision here, and the test is as follows. Quote, the extent to which the transaction was intended to affect the plaintiff, the foreseeability of harm to him, the degree of certainty that the plaintiff suffered injury, the closeness of the connection between the defendant's conduct and the injury suffered, the moral blame attached to the defendant's conduct, and the policy of preventing future harm." Close quote. And the court concluded in this case that the contractor's complaint passes muster under the balancing test. And the court reached that for the following reasons. Quote, "URS's construction plan preparation and instructions to Harris to redo certain work were acts that URS had to have known would directly affect Harris. It was foreseeable and fairly certain that Harris would suffer economic harm if URS managed the project poorly, and URS's development of project specs directly affected the work Harris performed. In short, Harris asserts a high degree of economic control by URS that was the purpose recognized in Colbert decision as supporting a cause of action." Close quote. The fourth case we'll discuss in this newsletter is entitled "No Damage for Delay Clause Enforced Even if Delay is Caused by the Owner's Breach of Contract and Arbitrary Actions." Following a 3-month trial, a jury awarded a contractor judgment of almost $19 million for breach of contract by the Port of Houston. These damages represented the contractor's increased cost incurred because of having to switch from its proposed frozen wall cutoff design system to something completely different because the project owner rejected its shop drawing submittal that contained this system. And of course the contractor argued that this was its means and methods, that it was entitled to come up with its own way of accomplishing this. The owner should not have, one, taken so long to reject the proposal, and two, shouldn't have rejected it at all. So the basis of the award, because the jury did find in favor of the contractor here, and the basis for the award was stated by the jury as being entirely, quote, delay and hindrance to the contractor's work by the port. So although the contract contained a very tough no damage for delay clause, the trial court declined to enforce the clause. And this was because the court determined that as a matter of law, the port could not enforce it to preclude delay or hindrance damages that resulted from any action by the port that constituted arbitrary or capricious conduct or active interference or bad faith or fraud. Now those are all very typical exceptions to being able to enforce a no damage for delay clause. Courts all around the country typically look at those factors, and if there's been active interference, the court says that was not within the contemplation of the parties when they agreed to a no damage for delay clause. And so that's what the Texas trial court did here, was it applied this normal common law that we see throughout the country. But on appeal, that was reversed on the basis that the exceptions to the no damage for delay clause should not have been applied. This case was called Port of Houston versus Zachary Construction, 377 Southwest 841, Texas 2012. I'm going to put up a slide here showing the court's reasoning. And the reasoning was as follows, quote, "However, the parties are free to negotiate and agree upon the conditions under which the contractor will recover damages for delay, and another remedy is available to the contractor for any such delay." In June 2004, Zachary unambiguously agreed that it would perform the contract without the benefit of delay damages, even if the delay was caused by the port's breach of contract, negligence, or other fault. Zachary faced significant delays. Delays, it alleged, and the jury agreed, were caused by the port's breach of contract. In November 2005, Zachary proceeded with construction, quote, "in the wet," close quote, knowing the contract afforded no damages for delay. "We cannot rewrite the provision without depriving the port of the benefit of the bargain the parties reached in June 2004, close quote. Now, the actual contract clause that the court was interpreting reads as follows. I'm going to put up a slide with the language. Quote, The contractor shall receive no financial compensation for delay or hindrance of the work. In no event shall the Port Authority be liable to the contractor or any subcontractor or supplier, any other person, or any surety for or any employee or agent of any of them for any damages arising out of or associated with any delay or hindrance to the work, regardless of the source of the delay or hindrance, including events of force majeure, and even if such delay or hindrance results from, arises out of, or is due to, in whole or in part, to the negligence, breach of contract, or other fault of the Port Authority. The contractor's sole remedy in any such case shall be an extension of time." Close quote. Now, the all-cap language that you see in the clause was, in fact, just that way in the contract. They very intentionally made it all caps like that. In applying the contract clause, the court stated that although the parties had already stated the source of the delay was immaterial, they actually gave special emphasis to their intent that the delay, even due in part to the conduct of the port that was something like breach of contract, would be something that they were specifically contemplating. Moreover, the court said that the use of all capital letters for the matters regarding the port's conduct to set it off from the rest of the paragraph really had to be important, had to be looked to as significant here. And finally, the court said, to give utmost emphasis, the parties described the three categories of fault. 1 being negligence, 2 being breach of contract, and 3, other fault. And all of this was enough for the court to conclude that the parties intended that the waiver of damages was intended to apply to situations including that at issue in this case. I'd like to make a comment on this case. Courts in most states do, as I mentioned, apply a common law standard like that was used by the trial judge in this case to limit enforcement of a no damage for delay clause. In Texas, however, as demonstrated by the appellate decision here, the courts generally favor enforcing contracts just the way they're written, with very few exceptions, so long as the language is clear and ambiguous and not otherwise contrary to law or public policy. So this decision really demonstrates the importance of negotiating contract terms and conditions that reasonably allocate risk, because certainly in Texas, you can't sign a contract with what might look like an onerous, unreasonable clause and hope that the court will undo that contractual bargain and create a more fair and reasonable, equitable contract. That wraps up this particular newsletter. Hope you'll come back and read future newsletters and watch future videos. Thanks. Goodbye.